Which of the following organizations is most likely to fall outside the scope of the Privacy Act 1988? A. A private tech company with an annual turnover of $7 million that sells user data to third parties. B. A federal government department that collects health information for policy design. C. A sole trader accountant operating with an annual turnover of $2 million and no health-correlated services. D. A not-for-profit aged care facility with a turnover above $3 million and government funding. The correct answer is C, a sole trader accountant operating with an annual turnover of $2 million and no health-correlated services. Explanation. Under the Privacy Act 1988, the scope generally applies to app entities, which include Australian government agencies and private sector organisations with an annual turnover of $3 million or more. Small businesses with a turnover of less than $3 million are exempt unless they trade in personal information, provide health services, or are contracted service providers for a government agency. Since the accountant in option C has a turnover below $3 million, is not trading in personal information, and does not provide health services, they are likely exempt from the Act. Which of the following is the best justification for an app entity using an individual's personal information for a secondary purpose without obtaining consent? A. The secondary purpose is unrelated but helps internal marketing teams. B. The individual might not object to the use if asked. C. The secondary purpose is directly related to the primary purpose and within the individual's reasonable expectations. D. The personal information is not particularly sensitive. The correct answer is C. The secondary purpose is directly related to the primary purpose and within the individual's reasonable expectations. Explanation. Under App 6, personal information must only be used or disclosed for the primary purpose for which it was collected unless the individual has consented, or the secondary purpose is directly related for sensitive information or related for non-sensitive information and the individual reasonably expect the use or disclosure. Option C meets this legal test. Reference: App 6, Privacy Act 1988. Schedule 1. Scenario: a fitness app company fails to notify users of a data breach affecting over 10,000 user profiles, including sensitive location data. A group of affected users files a complaint with the OIC. What is the most likely outcome if the OIC upholds the complaint? A. The OIC will immediately shut down the company. B. The OIC may issue a legally binding determination requiring notification and possible compensation. C. The company will be publicly fined by the Act. D. The users will be required to sue in civil court to receive any remedies. The correct answer is B. The OIC may issue a legally binding determination requiring notification and possible compensation. Explanation. Under Sections 52 and 33 of the Privacy Act, the OIC can issue binding determinations, order organizations to compensate individuals, direct entities to take specified actions, such as breach notification. Criminal penalties and shutdowns require separate legal proceedings. Under Australian privacy laws, in which situation can personal health information be used without consent for public health research purposes? A. When the research is funded by the government. B. If the identified data is used for statistical research and individual identities are not reasonably ascertainable. C. If the patient has not objected to their data being shared. D. Whenever an ethics committee approves it, regardless of data identifiability. The correct answer is B. If the identified data is used for statistical research and individual identities are not reasonably ascertainable. Explanation. Under App 6 and Section 16, personal health information may be used for public health or medical research without consent if the information is de-identified, or if an approved human research ethics committee waives the need for consent and strict conditions are met. De-identification is robust enough that re-identification is not reasonably possible. Scenario: Linda is a data officer at Medalet Health Ltd, a private health service provider. One of the company's cloud storage providers recently experienced a security breach exposing encrypted health records of clients. Although the breach was quickly contained and data access was limited, the encryption keys were stored in the same compromised environment. What should Linda and the organization do in line with the Privacy Act 1988? A. No action is required as the data was encrypted. B. Notify only affected customers privately and avoid public disclosure to maintain trust. C. Assess whether the breach is likely to result in serious harm and, if so, notify the OIC and affected individuals. D. Delete all affected records and move on since the incident has been contained. The correct answer is C. Assess whether the breach is likely to result in serious harm and, if so, notify the OIC and affected individual's explanation. Under App 11 and the Notifiable Data Breaches NDB Scheme 2018, an organization must take steps to assess a data breach within 30 days and notify individuals in the Office of the Australian Information Commissioner (OIC) if it is likely to result in serious harm. This case, even though the data was encrypted, the presence of encryption keys in the same environment significantly increases the risk of serious harm. Reference: Privacy Amendment, Notifiable Data Breaches Act 2017, App 11. Which of the following best describes an app entity's responsibility when disclosing personal information to an overseas recipient under App 8? A. The app entity must always obtain written consent from the individual. B. The app entity must take reasonable steps to ensure the overseas recipient does not breach the app. C. The app entity is not responsible once the information is transferred overseas. D. Disclosure is only allowed if the recipient is in the European Union. The correct answer is B. The app entity must take reasonable steps to ensure the overseas recipient does not breach the app's explanation. Under App 8, an app entity must take reasonable steps to ensure that the overseas recipient does not breach the apps unless the individual expressly consents after being informed. The recipient is subject to similar privacy laws or an exception applies under Section 16. Thus, option B best captures the requirement. The entity may remain liable for breaches by the overseas recipient. Reference: App 8 Privacy Act 1988 and Section 16, accountability for overseas disclosures. Which of the following actions demonstrates the most comprehensive and compliant approach to data breach response under the Privacy Act 1988 and OIC guidance? A. Appointing a third-party forensic firm only after a formal OIC complaint is lodged. B. Publicly disclosing the breach via social media and waiting for affected individuals to self-identify. C. Temporarily shutting down systems and deleting compromised data before assessing potential harm. D. Activating the organization's data breach response plan containing the breach, assessing serious harm within 30 days and notifying both the OIC and affected individuals if required. The correct answer is D. Activating the organization's data breach response plan containing the breach, assessing serious harm within 30 days and notifying both the OIC and affected individuals if required. Explanation: Under the OIC's Data Breach Preparation and Response Guidelines and Section 26 of the Privacy Act, an entity's response to suspected or confirmed eligible data breach must include activation of breach response, including key decision-makers and communications officers' containment of the breach to prevent further data loss, assessment within 30 calendar days to determine if the breach is likely to result in serious harm, notification to the OIC and affected individuals if the breach is assessed as eligible. Which of the following scenarios would most likely constitute a breach of App 7 by a private organization? A. Sending a marketing email with an unsubscribe option. 2. A new customer who provided their email during a purchase. B. Using third-party sourced email addresses to conduct a marketing campaign without consent. C. Sending a birthday discount code to a long-term client. D. Notifying customers in the privacy policy that their personal information may be used for marketing. The correct answer is B. Using third-party sourced email addresses to conduct a marketing campaign without consent. Explanation: App 7 prohibits the use of personal information for direct marketing unless the individual has consented or there's an existing relationship and the individual would reasonably expect the use and an opt-out is provided. Option B involves unsolicited marketing to individuals whose consent is not obtained. Clear breach under App 7. Reference: App 7 Privacy Act 1988. Which of the following circumstances would most likely bring a small business under the Privacy Act's jurisdiction despite earning less than $3 million in annual turnover? A. Employing more than 20 staff. B. Having a professionally designed website. C. Providing counseling and health services to clients. D. Offering loyalty cards that track purchases. The correct answer is C. Providing counseling and health services to clients. Explanation: The Privacy Act 1988 generally exempts small businesses $3 million turnover, but exceptions include businesses that provide health services, those that trade in personal information, contracted government service providers, etc. Option C directly refers to health services, making the business an app entity regardless of turnover. Reference Section 6 4C Privacy Act 1988. Scenario: Rebecca is the privacy officer at a mid-sized insurance brokerage. She notices that several client onboarding forms have missing privacy notices and some staff are unsure about consent procedures when sharing data with underwriters. Which of the following actions would best align with Rebecca's legal responsibilities under the Privacy Act 1988? A. Conduct full internal privacy audit and implement training program for staff. B. Wait until the OIC issues warning before taking any action. C. Delete all previously collected customer forms to avoid breach. D. Assume compliance as long as no formal complaints have been made. The correct answer is A. Conduct a full internal privacy audit and implement a training program for staff. Explanation: Privacy officers are responsible for ensuring compliance with the apps across the organization, proactive internal assessments and remediation and education following privacy risks. A privacy audit and staff training align with App 1, open and transparent management, and OIC's expectations of privacy by design. Reference Guidelines, App 1.2 and OIC Privacy Management Framework. Scenario: Farah works in a private employment agency that assists refugees in finding work. The agency collected sensitive background information from clients for job placement. A non-profit mental health service asks Farah to share clients' trauma histories to improve counseling sessions. What should Farah do in compliance with the Privacy Act? A. Share the information if it helps the clients. B. Share the information since both agencies are non-profit. C. Refuse to share the data unless express consent is obtained from each client. D. Share only if the mental health service signs confidentiality agreement. The correct answer is C. Refuse to share the data unless express consent is obtained from each client. Explanation: Under App 6 and App 3, sensitive information requires express consent for use or disclosure. The disclosure must relate to the primary purpose or be required or authorized by law. Sharing trauma histories, sensitive personal info without consent, even to help clients, is unlawful. Reference App 6 and 3. Privacy 1988. Scenario: Zara operates a mobile wellness app. When users install the app, they are asked to allow access to their health data to improve service quality. However, Zara also shares anonymized user trends with advertisers. Which of the following best describes the consent model required for the data sharing? A. Express consent must be obtained since health data is sensitive. B. Implied consent is sufficient for any anonymized data. C. No consent is needed because anonymized data is not covered under the Act. D. Express consent is only needed if data is sold to third parties. The correct answer is A. Express consent must be obtained since health data is sensitive. Explanation: Health data is classified as sensitive information under the Act, and its use or disclosure, even for secondary purposes, requires express consent. Anonymization must be irreversible to fall outside the Act. Until that's ensured, consent must be assumed as necessary. Reference App 3.3 OIC's Guidelines on Sensitive Information. Which of the following measures would most likely satisfy the requirement under App 11 to protect personal information from misuse or unauthorized access? A. Having staff sign a confidentiality agreement once when hired. B. Encrypting data in storage and transit with periodic security audits. C. Keeping sensitive data in password-protected spreadsheets. D. Relying on third-party vendors to manage all data security. The correct answer is C. Encrypting data in storage and transit with periodic security audits. Explanation: App 11 requires entities to take reasonable steps to protect personal information from misuse, interference, loss, and unauthorized access, modification, or disclosure. Encryption, access controls, security training, and auditing practices are considered reasonable steps. Password-protected spreadsheets, option C, are not sufficient alone. Reference App 11 Guidelines by OIC. Which of the following would not be considered? Personal information under the Privacy Act 1988. A. Customer's home address stored in URM system. B. An anonymous survey response that cannot be linked back to the participant. C. Staff members' salary stored on the company's server. D. Unique device identifier used in behavioral tracking. The correct answer is B, an anonymous survey response that cannot be linked back to the participant explanation. The Privacy Act defines personal information as information that identifies or could reasonably identify an individual. B is excluded because it's truly anonymous and not reasonably re-identifiable. Even device identifiers D can be personal information if they can be linked to person. Reference Section 6(1) Privacy Act 1988 Guidance on Personal Information. Which of the following actions is a permitted use of a government-related identifier by a private sector app entity? A. Displaying a client's Medicare number on their company profile. B. Using driver's license number as customer ID in the database. C. Verifying client's identity during regulated compliance check. D. Using passport number to segment customers for marketing. The correct answer is C. Verifying a client's identity during regulated compliance check. Explanation. Under App 9, private entities must not adopt, use, or disclose government-related identifiers unless required or authorized by law, or reasonably necessary to verify identity for legal obligations. Option C is permitted because it falls under identity verification as required by compliance laws, e.g., anti-money laundering. Reference App 9, Privacy Act 1988. Which of the following statements about breach notification under the NEB scheme is most accurate? A. Notifications are only required if more than 100 individuals are affected. B. Only the Office of the Australian Information Commissioner, OIC, must be notified. C. Notification is mandatory only if the harm caused is financial. D. Both the OIC and affected individuals must be notified if serious harm is likely. The correct answer is D. Both the OIC and affected individuals must be notified if serious harm is likely. Explanation. Under the NDB scheme, if the breach is likely to result in serious harm, then the OIC must be notified and affected individuals must be informed with a statement outlining description of the breach, information involved, recommended steps for protection. Scenario: Jason's company, Eduport Australia, stores student data on servers located in Singapore. Before exporting new student records, Jason must ensure the recipient server provider complies with privacy protections similar to Australia's. What is Jason's best legal option under App 8 before disclosure? A. Rely on Singapore's national laws and proceed. B. Inform students and assume implied consent. C. Take reasonable steps to verify that the recipient complies with the app's or comparable scheme. D. Avoid the transfer unless OIC grants an exception. The correct answer is C. Take reasonable steps to verify that the recipient complies with the app's or a comparable scheme. Explanation. Under App 8.1, before cross-border disclosure, an entity must take reasonable steps to ensure the recipient does not breach the apps or ensure the individual consents after being informed of the implications. Singapore's laws may or may not be adequate, so verification and documentation are critical. Reference App 8 SE Privacy Act 1980. Which of the following best distinguishes between de-identified and anonymized data under the Privacy Act 1988? A. Anonymized data can be re-identified with proper authorization, while de-identified data cannot be. De-identified data retains some risk of re-identification, whereas anonymized data has had all personal identifiers irreversibly removed. C. De-identified data is always considered personal information, whereas anonymized data is always exempt. D. De-identified data is encrypted, while anonymized data is stored in secure facility. The correct answer is B. De-identified data retains some risk of re-identification, whereas anonymized data has had all personal identifiers irreversibly removed. Explanation. Under OIC guidance, de-identified data has had identifiers removed or altered but could potentially be re-identified, particularly if linked with other data. Anonymized data has been processed in such a way that re-identification is not reasonably possible, making not personal information under the Act. The distinction is critical for determining legal obligations under the Privacy Act, as de-identified data may still be regulated. Reference OIC Guidelines on De-identification, Privacy Act 1988. Under the Privacy Act, which of the following best describes a notifiable data breach? A. Any unauthorized access or disclosure of personal information. B. Data breach that results in temporary service outage. C. Data breach likely to result in serious harm to any of the affected individuals. D. Any suspected cyber incident involving data storage or networks. The correct answer is C, a data breach likely to result in serious harm to any of the affected individuals. Explanation. A notifiable data breach in EB is defined in the Privacy Amendment Notifiable Data Breaches Act 2017 as a breach involving personal information that is likely to result in serious harm and the organization has not been able to prevent the risk through remedial action. The serious harm includes emotional, reputational, economic, and financial harm. Reference Section 2626 of Privacy Act 1988. Scenario: Michael works at a digital health startup that offers online consultations. During account creation, users must tick a box that says, "By using our services, you agree to our data sharing policy." This policy allows the startup to share client data with marketing affiliates. Which of the following best describes the type of consent given by users under the Privacy Act 1988? A. Express consent because users tick box and accept the terms. B. Implied consent because the consent was inferred from user behavior. C. No valid consent as the sharing of data with third parties requires specific and informed agreement. D. Express consent as long as the user read the privacy policy before signing up. The correct answer is C, no valid consent, as the sharing of data with third parties requires specific and informed agreement. Explanation. According to OIC guidelines, express consent must be informed, specific, current, and voluntary. Simply clicking a generic agreement without clearly identifying third-party data used does not meet the threshold of express or valid implied consent. Organizations must highlight third-party disclosures clearly and obtain active agreement, particularly for sensitive data. Reference OIC Guide to Consent under the Privacy Act. Which of the following best illustrates reasonable steps for protecting personal information under App 11? A. Allowing staff to access all customer data so they can assist if needed. B. Encrypting personal data, regularly updating security protocols and monitoring for breaches. C. Deleting all data older than 6 months. D. Only training managers on data security practices. The correct answer is B, encrypting personal data, regularly updating security protocols, and monitoring for breaches. Explanation. Under App 11, entities must take reasonable steps to ensure security of personal information against misuse, loss, and unauthorized access. Reasonable steps may include encryption, multi-factor authentication, access controls, regular audits, staff training. Option B reflects industry standard security practices in alignment with the OIC's guidance. Reference OIC Guide to Securing Personal Information. An organization collects customer biometric data to streamline security processes. However, some users raise concerns about how their biometric templates might be stored and used in future analytics. Which of the following ethical responses best aligns with both the Privacy Act and ethical best practice? A. Provide transparent, detailed privacy notices and offer an opt-out or alternative for individuals concerned with biometric data usage. B. Proceed with the collection since the biometric data enhances organizational efficiency. C. Suppress internal discussion on ethical concerns until customers file formal complaints. D. Claim that the data is anonymized and exempt from further obligations. The correct answer is A. Provide transparent, detailed privacy notices and offer an opt-out or alternative for individuals concerned with biometric data usage. Explanation. Biometric data is classified as sensitive information under the Privacy Act. Its use requires explicit, informed consent, must be proportionate to purpose, and must not create unnecessary power or trust imbalances. Ethical privacy management involves transparent respect for autonomy and offering meaningful choices. Scenario: Ollie is the privacy officer for an online education platform that tracks user activity for improving user experience. Recently, a school board asked the platform to share identifiable user engagement data without consent for evaluating teacher performance. What is the most appropriate ethical and legal action? A. Comply with the request to maintain the business relationship. B. Anonymize the data and provide it regardless of consent. C. Share the data only if the terms of use mention third-party sharing. D. Refuse the request unless there is valid user consent or a lawful basis for disclosure. The correct answer is D. Refuse the request unless there is valid user consent or a lawful basis for disclosure. Explanation. Under App 6, personal information can only be used or disclosed for the primary purpose or a permitted secondary purpose with consent or a legal basis. Ethical decision-making also requires applying the Reasonable expectations test, balancing user privacy with third-party interests, ensuring no overreach of purpose or trust-sharing user activity with third parties without consent would breach App 6.1 unless a legal exception applies. Scenario: a hospital receives a subpoena from law enforcement requesting access to a patient's full medical record as part of criminal investigation. The privacy officer is unsure whether to disclose the information without patient consent. What is the most appropriate course of action under the Privacy Act 1988? A. Disclose the information if legally compelled and ensure the disclosure is documented as an exception to App 6. B. Deny the request entirely unless the patient provides written consent. C. Provide the full record immediately and notify the patient afterward. D. Delete the record and claim it no longer exists to avoid breaching either party's rights. The correct answer is A. Disclose the information if legally compelled and ensure the disclosure is documented as an exception to App 6 explanation. Under App 6, personal and sensitive information must not be disclosed except where the individual consents or an exception applies, such as when required or authorized by Australian law, e.g. subpoena, warrant. Documentation is critical to ensure transparency and legal compliance, or destroying records would breach both ethical duties and record-keeping obligations. Reference App 6.2b. App Guidelines. Law enforcement disclosures. Which of the following best demonstrates the correct application of express consent under the Privacy Act 1988? A. Pre-ticked boxes on a website agreeing to marketing communications. B. Assuming consent because a user continued to use the service after reading the privacy policy. C. Implied consent based on historical customer interaction. D. A clearly worded affirmative action where the user ticks a box indicating agreement to data sharing for specified purposes. The correct answer is D. A clearly worded affirmative action where the user ticks a box indicating agreement to data sharing for specified purposes. Explanation. Under OIC guidance, express consent must be voluntary, informed, current, specific. Scenario: Dominic is a compliance manager at a fintech company. The company experiences a breach involving 50,000 customer email addresses and hashed passwords. They are unsure whether to notify the OIC and affected customers. Dominic argues they should wait until more evidence of harm emerges. What is the most legally appropriate course of action under the NDB? A. Conduct a prompt and reasonable assessment of the breach within 30 calendar days to determine the likelihood of serious harm. B. Notify the OIC immediately, even without assessing harm, to demonstrate good faith. C. Only notify if customers complain or experience harm. D. Assume no action is necessary since the passwords were hashed. The correct answer is A. Conduct a prompt and reasonable assessment of the breach within 30 calendar days to determine the likelihood of serious harm. Explanation. Under Section 26 of the Privacy Act, organizations that suspect an eligible data breach must carry out a reasonable and expeditious assessment. Complete the assessment within 30 calendar days. If serious harm is likely, they must notify both the OIC and affected individuals. Does not guarantee security, especially if weak algorithms are used. Scenario: Lucas is a compliance officer at a telecom firm that stores metadata, e.g., call times, IP addresses, in overseas cloud servers. Recently, customers raised concerns about data sovereignty. What is Lucas's primary legal concern under Australian privacy law? A. Ensuring the metadata is stored only in paper format. B. Verifying that overseas providers comply with App 8 before disclosing any personal information. C. Ensuring that metadata is retained for only 6 months. D. Disabling the servers during public holidays. The correct answer is B. Verifying that overseas providers comply with App 8 before disclosing any personal information. Explanation. Under App 8, entities must ensure that cross-border disclosures only occur where the recipient complies with app equivalent standards or the individual consents after being informed. Even metadata may be considered personal information if it can identify or profile an individual. Data sovereignty in cloud jurisdiction are critical concerns under both App 11, security, and App 8, cross-border disclosures. Which of the following best reflects the requirements for obtaining valid consent under the Privacy Act 1988, particularly when engaging with vulnerable populations such as the elderly or individuals with cognitive impairments? A. Consent must be informed, voluntary, current, specific and given by an individual with the capacity to understand the implications. B. Consent may be inferred from non-response to a clearly stated privacy notice. C. Consent is valid as long as it is written and stored in the client record, regardless of comprehension. D. Consent can be provided by any family member when engaging with individuals over the age of 70. The correct answer is A. Consent must be informed, voluntary, current, specific, and given by an individual with the capacity to understand the implications. Explanation. According to the OIC's Guidelines on Consent, updated for the Privacy Act 1988, valid consent, especially in contexts involving vulnerable populations, must meet all of the following criteria: informed, the individual must understand what they are agreeing; voluntary, must be given freely, without pressure; current and specific, not blanket or outdated capacity. The individual must have the legal and cognitive capacity to provide consent, particularly important when engaging with the elderly, minors, or people with cognitive disabilities. Which of the following is a remedy available to an individual if the OIC determines there was an interference with their privacy? A. Mandatory criminal charges against the organization. B. Suspension of the organization's license. C. Compensation, apologies, or enforceable undertakings ordered by the OIC. D. Automatic deletion of all data held by the entity. The correct answer is C. Compensation, apologies, or enforceable undertakings ordered by the OIC. Explanation. The OIC can order remedies under Section 52 of the Privacy Act, including financial compensation, written apologies, corrective actions, and enforceable undertakings under Section 33. The Act does not provide for automatic criminal liability or licensing actions, which fall under separate regulatory schemes. Which of the following is the most appropriate action for a financial advisor sharing a client's financial profile with an external underwriter? A. Do so without client consent as long as the privacy policy covers it. B. Share only after obtaining express consent and ensuring the underwriter complies with the app. C. Allow access to the underwriter's entire database in exchange for quote. D. Share the data with the client's spouse for convenience. The correct answer is B. Share only after obtaining express consent and ensuring the underwriter complies with the app's explanation. Financial data often includes sensitive personal information, particularly where health or insurance underwriting is involved. App 6 and App 8 require express consent for secondary use or disclosure of reasonable steps to ensure the recipient handles the data appropriately. Sharing based only on privacy policy language does not meet the threshold for consent under OIC standards. Reference App 6, App 8. Privacy Act 1988.